And that is what Carol Gaddy is doing this morning in jail in Sequatchie County. She's doing her duty. She's not giving in. She has the means of resistance. She has the means of saying, she has the means of walking out of that cell today. But she has to say yes to something which the party who receives that affirmative from her has no authority to receive and no authority to act upon. And that is Judge Thomas Graham of Chancery Court, who has her in jail in a most unusual and perhaps wondrous way. She is in jail because she is refusing to grant voluntary consent to a search of her house on Main Street in Dunlap. This is a privately owned house, and it is a house in good condition. There's nothing wrong with it. And yet, the mayor, Dwayne Land, demands the authority to search this house in what he calls an inspection. And he's making that demand apart from any averment or swearing on his side or on his part that there is a suspicion of a crime having been committed in that house, or a dead body having been buried there, or stolen bank bags on deposit under the floorboards there, or anything of the kind. There's no allegation of a crime. And yet the mayor, under an ordinance, says that we're tearing this house down unless you let us search it. It is seemingly vindictive. It seems to me miraculously without a basis in the law or in observable fact regarding this property that he, from the outer border of it, inspected 2 years ago when he made his determination that this house is dilapidated and a danger to the inhabitants and a danger to the public, that somehow the whole thing may fall down in a roar, and planks and beams and brick and nails go flinging out across the line of the property over the creek, over Coops Creek even, to the ramshackle neighbors' houses as well, and injure those people. We simply cannot have this house run and owned by Thomas and Carol Gaddy without our inspecting it. It is more than just a public safety issue, though. There is something personal. There's something grievous. There's something gnawing, it seems, in Dwayne Land's approach and his unwillingness to let it go. He survived reporting on this case in one re-election for mayor, so he has, it seems, the backing of the public. The newspaper, the Dunlap News in Dunlap, having not covered the case perhaps as it should have, and the people and their anger not given an arousal by the simple reporting of the court case that has been going for 2 years. There's been a periodical article here and there, maybe two in the past few months. I've done about 15 or 20 about this story, which is important because it's about an idea, the idea of your castle, the idea of being free from the officer, about being free from any claim against you unless there is a cause for that claim. That cause is called probable cause. And we have a weakened version of that operates in the back of minds of police officers, and that's an articulable suspicion. And that is that a crime has been committed, a crime has been seen committed, there's a warrant sworn that a crime has been committed, that this person has done it. That would be an arrest warrant, or there's a warrant, a signed warrant by a judge, signed by a judge, right? The dispassionate, disinterested third party that the law requires. And that warrant says that this car or this house contains something that is proof of a crime and must be searched. It must be searched. And then there is no resistance. Then Mrs. Gaddy has no standing, no ground with which to say no. She can simply just be silent and the inspection or the search takes place. But what's happened is there's a demand for a search on a house in which there's no criminal allegation made by the chief instigator. That's the mayor of Dunlap, Mayor Dwayne Land, who's a big property owner, by the way, a big landlord. He's go to Nooganomics.com and find my very fair report about Mayor Dwayne Land as landlord, and meet some of the people who are his estimable tenants. And I'm very much for the free market, by the way, and I'm very much for substandard housing, and I'm for it because that's what poor people can afford. And Mayor Dwayne Land serves that market interest of serving the floor of the marketplace, and that is what he does with these trailer homes. Now, you, my listener, you're a kind of a snooty person. You're reading that story at Nooganomics.com about the mayor land bid for re-election. And you, I know, will be probably prejudiced, unless, of course, you've read me a while or at Nooganomics.com or have heard my analyses of the market, which really has nothing about prejudice at all in it. And so I say that I'm all for low-level housing. I'm all for cheap housing. I'm all for trailer parks. Trailer parks are an important service in the marketplace economy because who lives there? Well, people who have no capital, who have shabby jobs, no means of support, and they live as cheaply as they can in apartments that often are have rotted floorboards and leak and may have old pipes and may have been occupied by dozens of transient families with their rough kids and related parties living in with them before you get the place, right? And yet those are good. Those are good. The marketplace needs cheap housing. And in fact, one of my arguments here on the David Tulis show is we need to have cheap housing in Chattanooga, and that there's a grave problem that mayoral challenger Chris Long brought up in the campaign, and that is that we need to have a housing market that takes care of the homeless, and that is something that only the free market can offer as a solution. No policy, no affordable housing poppycock talk can remedy that problem. It has to be done by the marketplace, but that has to be done by people who are willing to let the marketplace operate apart from their good intentions, right? That is to say, apart from Democratic intentions, Republican intentions, and people who are willing to let people be people, right? Let the poor be poor. You'll always have them with you, and you can always do them a good turn. The Lord said to those who complained about the woman with the balm of spikenard that she poured upon him, as he said, to prepare him for burial. We will always have the poor with us. And so it's good to account for the poor. It's good to have housing for the poor. And Mayor Dwayne Land in Dunlap serves that market. And so my report is, you might say it's kind of an odd report because it seems to condemn him for harassing Mr. and Mrs. Gaddy. And it doesn't actually say that this is an evil act, but you can tell from the coverage that I view this as unconscionable and that he's personally liable to this couple. He's personally liable for everything he's done against them in the past 2 years. This is not, all that's happening is apart from lawful authority. The mayor, and I suggest even the judge, Judge Thomas Graham and Steve Greer, the city attorney, these people are not free from personal liability for their abuse of the process, the abuse of the courts, and there's several important mistakes that Steve Greer has made with Dwayne Land. He's counseling Dwayne Land, serving the executive branch of city government, and there are several of them. The first one is that the court, the Chancery Court, has no jurisdiction. It has no subject matter jurisdiction because the law controlling this case requires the case to be heard in city court, and the case never went to city court. It simply was bypassed. You cannot ignore what the legislature requires of all disputes under ordinance, and that is that dispute be heard in the city court, not chancery, not circuit, city. That's why it's called private law. Dunlap is controlled by private law, a law written by the legislature for that town alone, right? That's what's called private law. And so disputes about rules regarding properties have to be settled in city courts. That's the first mistake, and that seems to me just so obvious. It just seems so obvious. And all that's happened in 2 years for this beleaguered couple has been in Chancery Court outside of authority. And the question is, among others, is there a power in the municipal need of an inspection? Is there a power to overwhelm and defeat constitutional guarantees? That is to say, guarantees given by God, protected by the Constitution, that are rights that are inalienable and inherent in the persons in question. That would be Mr. and Mrs. Gaddy. She is in jail today in Sequatchie County, and Thomas Gaddy is in hiding again. Right? They've been hiding for months under an order of a finding of contempt. Now here comes another issue that I was looking at this morning, And I've got many pages of reading still to do on contempt, but there's civil contempt and criminal contempt. And the problem with the finding of contempt is that there's no punitive part of the ordinance, right? So how can there be a punitive finding by the judge if there's no punitive finding in the ordinance, right? In other words, if the ordinance doesn't say, the ordinance should say, well, let me back up here. The ordinance says that it's ordinance, I think 66. There is an interest in the public health, safety, and welfare. I don't have it in front of me, but there is no enforcement mechanism in the ordinance. If there's not an enforcement mechanism for someone who says no to an inspection of a private house in which there's no contract, right? There's no contract between the city or the private homeowner. Therefore, there can't be an equitable relationship. That is to say, there's no relationship in the law, right? There's no facts at issue. There's no connection. How can there be an enforcement with jail? And apparently, Kelly Gaddy, the son, says jail indefinitely for Mrs. Gaddy. How can that be? If the ordinance itself, of course, argued in the wrong court, doesn't have a punitive measure, doesn't have a punitive claim, how can the judge create a grievance against, as it were, against himself? And he's really saying, I'm offended by your not granting permission to search, right? I'm offended personally as a judge. My office is being thwarted. My office is being laughed at and being ridiculed by your refusing to obey my order to voluntarily consent to a search. And therefore, I'm holding you in contempt. And contempt is there a limit to it? I'm not sure. How long can it go? I don't know. And is it a genuine contempt, or is it an abusive finding of contempt? Theoretically, in civil contempt, you hold the key to your own release by simply granting what the judge wants, right? Complying with the order ends the finding of contempt. You bring yourself back into a state of grace. And Mrs. Gaddy is not going to say yes. And there's no underlying statute or ordinance that the judge is standing upon that says you have to grant voluntarily consent to search, even though there's no warrant and even though there's no probable cause. What we need in this story is an attorney here in Chattanooga, or maybe someone in Sequatchie County, who can stand up to the mayor, preferably an outside attorney who doesn't have personal connections up in that county, and to help this beleaguered Christian couple. They're both practicing Christians, and they are well-intentioned people and people of principle. As Nooganomics.com reported, Mrs. Gaddy says that for her not to stand on the Constitution, not to stand for her rights, is a slap in the face of the military veterans whom have served the country in its military foreign wars of adventure. Those men, as she sees it, fought and died for liberty, as she sees it, right? They gave us our freedoms, she thinks, right? So she does not want to, as she says, throw mud in their faces by yielding to an unwarranted claim, a claim outside of law, a claim I would like to suggest is being made personally and in their own human form by the mayor, Dwayne Land, by the judge, Judge Graham, and also by the attorney, who can't be freed from the machinations that have been in process against this couple for 2 years. That is to say, Steve Greer. His law office is just across the intersection from the mayor's town hall. And both of those buildings are a carbine shot away from the Gaddy house there behind the trees in the little bend in the river, the little bend in the creek there, Coops Creek. The house is built by a former judge at the time, just after probably 20 years or so after the Great War. And not, as the Gaddys suggest, not even in the city limits. And that's another question. There seems to be much room for doubt about the case of executive power aided by judicial affiliation, right? Judicial complicity, even in the claims against Mr. and Mrs. Gaddy. Is there power in a building code to have a mass compliance for a routine periodic inspection of all structures? It is here that the probable cause debate is focused. One court case says, for the agency's decision to conduct an area inspection is unavoidably based on its appraisal of conditions in the area as a whole. not on its knowledge of conditions in each particular building. The appellee, that is to say, in the Camara case, 1969, out of San Francisco, is a Supreme Court case, 1967 Camara versus Municipal Court. It says, it is here that the probable cause debate is focused. For the agency's decision to conduct an area inspection is unavoidably based on its appraisal of conditions, general, not on its knowledge of conditions in each particular building. Appellee contends that if the probable cause standard urged by the appellant is adopted, the area inspection will be eliminated as a means of seeking compliance with code standards, and the reasonable goals of code enforcement will be dealt a crushing blow. In other words, these are rationales for mass inspections without a warrant. In meeting this contention, appellant first argues that his probable cause standard would not jeopardize area inspection programs because only a minute portion of the population will refuse to consent to such inspections. And second, that individual privacy in any event should be given preference to the public interest in conducting such inspections. The first argument, even if true, is relevant to the question of whether the area inspection is reasonable within the meaning of the Fourth Amendment. The second argument is, in effect, an assertion that the area inspection is an unreasonable search. Unfortunately, there can be no ready test for determining reasonableness other than by balancing the need to search against the invasion which the search entails. But we think that a number of persuasive factors combine to support the reasonableness of area code enforcement inspections. So this is an argument kind of why Mayor Land may have a point. And this has been brought up to me in private conversations. These inspections have a long history of judicial and public acceptance. Second, the public interest demands that all dangerous conditions be prevented or abated. Yet it is doubtful that any other canvassing technique could achieve acceptable results. Many such conditions, faulty wiring, an obvious example, are not observable from outside, and indeed may not be apparent to the inexpert occupant himself. Finally, because the inspections are neither personal in nature nor aimed at the discovery of evidence of a crime, they involve a relatively limited invasion of the urban citizen's privacy. Both the majority and the dissent in Frank emphatically supported such a conclusion. But most people allow these inspections, but what about the person who won't? There is the question and the rub. In this case, the appellant has been charged with a crime for his refusal to permit housing inspectors to enter his leasehold without a warrant. There was no emergency demanding immediate access. In fact, the inspectors made 3 trips to the building in an attempt to obtain the appellant's consent to search. Yet no warrant was obtained, and thus appellant was unable to verify either the need for or the appropriate limits of the inspection. Right? You've got to have a warrant to know what's being looked for and the limit that limits the activity. No doubt the inspectors entered the public portion of the building with the consent of the landlord through the building's manager, but appellee does not contend that such consent was sufficient to authorize an inspection of the appellant's premises. Assuming the facts to be as the parties have alleged, we therefore conclude that appellant had a constitutional right to insist that the inspectors obtain a search warrant. In other words, Mrs. Gaddy is right to insist that Mayor Land have a warrant to inspect her house. This is a Supreme Court case, and it does not favor the mayor of Dunlap. The mayor of Dunlap needs to pay attention to Camara versus Municipal Court of City and County of San Francisco. He goes on to say, it appears from the opinion of the District Court of Appeal that under these circumstances, a writ of prohibition will issue to the criminal court under California law. The judgment is vacated, and that is what happens in that case. Now, there is some adjustment to that standard from 1967, but I think the main point for the Gaddy case is that you, my listener, have a right to have a warrant for any inspections. In other words, if any official wants to come on your property for a reason, it has to be a reason that a third party, a neutral party, has to approve of. Okay, so that means there has to be a claim of something wrong, a claim of a crime, a claim of a danger to the public, something. There has to be something. I'll be vague about it and general about it and say just that. And other than that, no official, no officer, no inspector, no regulator has any business on your land, especially if you say no, especially if you say no by notice or other. Please get off my property. You don't have a warrant. Get off my property now. That's polite and that's firm, but that's what you have to say, right? If you think that you are potentially a victim of the government, and many thousands of people are victims of government, millions of people in this country are victims of government. In fact, probably every person you know is a victim of government. Think just of inflation. Think just on that one point alone, the fact that we don't have constitutional coin and currency, and that local officials, state officials, allow the circulating medium of Federal Reserve notes in our economy without defending us. We're all victims. So here in this matter, if you are a potential victim of government, then you need to say no, get a warrant, and that's a very basic idea. And I think you should think about that even when dealing with Donna Williams at the Economic Development Office. She is starting a program of harassment now under Mayor Burke, harassment of people who are taking part in Airbnb, the online digital network that allows many more visitors to come to Chattanooga who might otherwise not come. And these visitors are staying in private houses through the platform of Airbnb and others. There are a bunch of them. And Donna Williams is now on patrol. She's patrolling the internet, and she's doing time-stamped screen grabs of people who are putting their houses on the market for private arrangements, right? Private arrangements of private houses by private people with other private people in other countries, right? And Donna Williams, the mayor's economic development official, is on patrol, and she's trying to snuff out private relationships that are for profit to both sides. Don't forget, just because the person who gets the money is getting money and the person who's coming into town is losing a little bit of money, don't forget that the person arriving thinks he's the one getting the steal, right? The person coming here thinks, man, I get to come to Chattanooga. I pay only $400, and I'm here for 9 days. And I'm in a private house, this beautiful house, let's say in Chattanooga. What a deal, right? So the visitor's profiting more than the homeowner in Chattanooga. And the mayor, without a warrant in any case, it's all done administratively, it's all done by notice, it's all done under a presumption of authority, has a surveillance program to stamp out the gig city. This is how the gig city is really just made a laughable position, because the mayor here, in a way somewhat like the mayor in Dunlap, is using an authority that's really not his. It's not his because the ordinance that he let the city council pass is unconstitutional. And it's unconstitutional for several grounds, as we've mentioned here on the David Tulis Show. And you, my listener, you have a better idea perhaps than your neighbor or your colleague or your friend at the golf course about this situation. There has to be a law to make people do something, or if there's an offense, there has to be a sworn application to a judge that an evil thing has been done, that there's a wrong being done, there's a proof of a crime in a particular house, and therefore we have to have state action to make the wrong right, to find the dead body, to find the violation, and that has to be sworn. That you can't do that just on your own whim. It has to be sworn before God and before a judge that there's a crime going on. We are so far away from constitutional government, it's not even funny. It's not even funny. This is David Tulis, and we're working our way back one mind at a time, starting with you. I do hope you stand your ground. At least just think about it. David Tulis.
The Tennessee Valley's news, talk, and